Below is a clear, exam-ready explanation of formation of an agreement under the Indian Contract Act 1872, sections 2 to 10, covering intention to create legal relations, offer and invitation to treat, kinds of offer, communication, acceptance and revocation, and modes of revocation. Formation of an agreement, Indian Contract Act 1872, sections 2 to 10. Agreement equals offer plus acceptance, Sec. 2E. Contract equals agreement plus enforceability by law, Sec. 2H. For a valid contract, Sec. 10, essential elements include 1. Free consent, 2. Competent parties, 3. Lawful consideration and lawful object, 4. Intention to create legal relations, 5. Not expressly declared void. Intention to create legal relationship. A contract requires parties to intend to enter legal obligations. Social domestic agreements, no intention, not enforceable. Example: husband promising to pay allowance to wife is not a contract. Commercial agreements, intention presumed. Though not explicitly stated in ICA, Sec. 10 requires enforceability, which implies intention. Offer, proposal, Sec. 2A. Definition: when one person signifies to another his willingness to do or abstain from doing something with a view to obtaining assent, he makes a proposal offer. Characteristics of an offer: must be communicated, must show willingness to be bound, must be definite and capable of acceptance. Invitation to treat, not an offer. An invitation to treat is only an invitation to make offers, not an offer itself. Examples: display of goods in a shop window, advertisements generally, catalogs, tenders, accept highest, lowest bid commitments. Distinction: offer equals readiness to be bound. Invitation equals invitation for others to make offers. Kinds of offer. Image 1, express offer, made in words, spoken, written. 2, implied offer, inferred from conduct, e.g. bus service. 3, specific offer, made to a specific person, only that person can accept. 4, general offer, made to public at large, anyone who performs conditions can accept. Carlyle v. Carbolic Smoke Ball Co. 5, cross offer, two identical offers crossing each other, no contract. 6, counter offer, variation of terms, destroys original offer. 7, standing offer, continuing offer, open for a period, acceptance by supply orders, e.g. government tenders. Hack communication, Sec. 3.4. Communication of offers, 4. Completed when it comes to the knowledge of the offeree. Communication of acceptance, Sec. 4. As against the proposer, when acceptance is put in course of transmission, postal rule. As against the acceptor, when it comes to knowledge of the proposer. Communication of revocation, Sec. 4. As against the person who makes it, when revocation is put into transmission. As against the person to whom it is made, when it comes to knowledge. Acceptance, Sec. B. When the person to whom the proposal is made signifies his assent, the proposal is accepted. Legal rules of acceptance. 1. Must be absolute and unqualified, Sec. 7. 2. Must be communicated. 3. Must be according to prescribed or usual mode. 4. Acceptance by conduct is valid. 5. Silence is not acceptance unless agreed. 6. Must be made before the offer lapses, revoked. Revocation, withdrawal, Sec. 6. Revocation of offer, Sec. 5 and 6. An offer can be revoked: 1. By notice of revocation, 2. By lapse of time given for acceptance, 3. By failure to fulfill a condition precedent, 4. By death or insanity of the offeror, if known to offeree, 5. By counteroffer, 6. By rejection by offeree, 7. By non-acceptance within reasonable time. Revocation of acceptance, Sec. 5. Acceptance can be revoked before it is communicated to proposer, i.e. before it reaches his knowledge. Modes of revocation of offer, 6. These include 1. By communication of notice from offerer, 2. By lapse of time, 3. By failure of condition precedent, 4. By death, insanity of offerer, 5. By counteroffer, 6. By non-acceptance. Quick revision table, topic, key points. Intention, necessary for enforceability. Offer, 2A, must be communicated, definite. Invitation, not an offer, only invitation. Kinds of offer: express, implied, general, specific, standing, cross, counter. Acceptance, 2 beats, must be absolute, communicated. Communication, 4. Offer, knowledge. Acceptance, transmission rule. Revocation, 6. Before acceptance. Several modes. If you want, I can also provide case law-based notes, 1-page summary chart, MCQs for practice. Just tell me. Clear exam-oriented explanation of making of an agreement. Special situations. Tenders and auctions under the Indian Contract Act 1872, sections 2 to 10. Act making of an agreement, special situations. Tender's image. A tender is a widely used procedure for procurement of goods, materials, or services, especially by government departments. It involves invitation to offer, submission of offers, and acceptance. A. Legal nature of a tender. Invitation to treat. An invitation for tenders, advertisement or notice, is not an offer. It is merely an invitation to treat, inviting interested parties to make offers. Case law, Spencer v. Harding, tender invitation is an invitation to offer, not an offer. Submission of tender. When a person submits a tender, that submission is an offer. The offer may be specific, only for one supply, continuing, standing offer, valid for a period and to be accepted through supply orders. That's just standing, continuing offers. A standing offer is an offer to supply goods as and when required over a period. It does not create a contract immediately. A contract arises each time an order is placed. Case law, Percival v. London County Council, standing offer becomes binding only when orders are placed. Characteristics. 1. Revocable any time before acceptance, i.e. before order. 2. Each supply order equals separate acceptance. 3. Revocation must be communicated. D. Revocation of tender, Secca 5. A tender, being an offer, can be revoked any time before acceptance, even if stated to be irrevocable, unless consideration is given, making it an option contract. Revocation is valid once communication reaches the invitee. 4. E. Acceptance of tender. Acceptance may be 1. Express, letter of acceptance, or 2. Implied, by placing the first supply order. Once accepted, a binding contract is created only for that order, unless the tender was for a single transaction. Auctions. Image auctions are governed by the general rules of the Indian Contract Act, sections 210, but TEF special principles. Nature of an auction sale. Bidders make offers. Auctioneer accepts. A bid equals offer. Fall of the hammer equals acceptance. Before the hammer falls, bidders may withdraw their bids. B. Legal rules in auctions. 1. Invitation to treat. The auction announcement display is not an offer. It is an invitation to offer. Each bid is a fresh offer. Talk 2. Acceptance. Acceptance happens when hammer falls or auctioneer announces sold. Acceptance must be communicated. 3. Withdrawal, revocation. Bidder's revocation. 5. A bidder may withdraw his bid any time before acceptance, before the hammer falls. Auctioneer's revocation. Auctioneer may withdraw the goods before acceptance. Cannot revoke after the hammer is down. Number 4. Reserve price, upset price. A seller may fix a reserve price. If highest bid is below reserve price, auctioneer need not accept it. Must be communicated or understood. 5. Pretended bidding puffers, Sec. 64. If the seller employs a puffer, fake bidder, to artificially raise bids, the sale is voidable at buyer's option. If it is a sale without reserve, but a fake bidder is used, sale is invalid. Number 6. Sale without reserve. Seller is bound to sell to highest genuine bidder. No withdrawal permitted after a valid highest bid. 7. Completion of sale, Sec. 64-2. A sale is complete when the auctioneer announces completion, usually hammerfall. After this, a binding contract arises. Difference between tenders and auctions. Feature, tender, auction. Nature, written competitive offers, public competitive bidding. Invitation, invitation to treat, invitation to offer, offer, tender document submitted, bid, acceptance, award placing of order, hammerfall or announcement. Revocation, before acceptance, before hammerfall. Role of authority evaluates tenders, conducts live bidding. Exam ready notes, tender notice equals invitation, not offer. Tender submission equals standing, specific offer. Standing tender becomes binding only when order is placed. In auctions, bid equals offer. Hammerfall equals acceptance. Bidder may revoke bid before acceptance, Sec. 5. Auctions with reserve price allow rejection of low bids. Sale complete when auctioneer announces completion, Sec. 64-2. Puffing, sale voidable. If you want, I can also create one-page summary for quick revision, short notes with case laws, MCQs for practice. Just tell me. Below is a complete exam-oriented explanation of consideration, its nature, privity, and exceptions under the Indian Contract Act 1872, focusing on sections 2D, 2F, 23, and 25. Meaning of consideration, Sec. 2 image. Statutory definition, Sec. 2D, when, at the desire of the promiser, the promisee or any other person has done or abstained from doing something, or does or abstains from doing something, or promises to do or abstain from doing something, such act or abstinence or promise is consideration. Key elements. 1. Must move at the desire of the promiser. 2. May move from promisee or any other person. Indian law differs from English law. 3. May be past, present, or future. 4. Must be real and lawful. Nature, basis of consideration. A. Consideration is the price of the promise. It is something in return for the promise. Without consideration, a promise becomes gratuitous and unenforceable. Sec. 25. B. Kinds of consideration. 1. Past consideration, act already done at promiser's desire. 2. Present, executed consideration, act done simultaneously. 3. Future, executory consideration, mutual promises for future performance. C. Consideration must be lawful. Sec. 23. Possible, real, not illusory. Not vague, something of value in the eyes of law. Doctrine of privity of contract and consideration. A. Doctrine of privity of contract. Only parties to a contract can enforce the contract or sue upon it. A stranger to a contract cannot sue, even if the contract is for his benefit. Case law. Dunlop Pneumatic Tire Co. v. Selfridge & Co. In India, M.C. Chaco v. State Bank of Travancore. B. Privity of consideration. Indian Position Indian Contract Act allows consideration to move from promisee or any other person. Sec. 2D. Hence, stranger to consideration can sue, but stranger to contract cannot sue. Exceptions to privity of contract. The contract may sue in the following cases. 1. Trust's beneficiary can enforce trust though not a party. 2. Family settlements, marriage arrangements, e.g. agreement for maintenance of a family member. 3. Acknowledgement or estoppel, where one party acknowledges liability to a third party. 4. Assignment of contract. Assignee can sue. 5. Contract through agent principal can enforce though agent signed. 6. Where charge is created on immovable property, beneficiary of charge can enforce. Exceptions to the rule no consideration, no contract, Sec. 25. Sec. 25 lists situations where agreement without consideration is valid. 1. Natural love and affection between near relatives, motivated by natural love and affection. Example, father executing registered gift deed for daughter. Number 2. Compensation for past voluntary services, Sec. 25(2). A promise to compensate a person who has voluntarily done something for the promiser. Example, A finds B's lost purse. B later promises to pay A. Number 3. Promise to pay time-barred debt. 25(3). A written and signed promise to pay a debt barred by limitation is valid. 4. Completed gifts. Gifts do not require consideration once completed. Sec. 25 Explanation 1. 5. Agency, Sec. 185. No consideration required for the creation of agency. 6. Charitable subscriptions, under certain conditions. If on the faith of the promise, the promisee changes position. Lawful consideration and object, Sec. 23. Consideration is unlawful if, forbidden by law, defeats provisions of law, fraudulent, injurious to person property, immoral, or opposed to public policy. If the object or consideration is unlawful, agreement is void. Quick revision table, topic key points. Meaning 2D, at promiser's desire, from promisee, other, past, present, future. Privity, only parties can sue. Indian law allows consideration from a third party. Exceptions to privity, trusts, family settlements, acknowledgement, agency, assignment. Exceptions to consideration, love and affection, past voluntary services, time-barred debt, gifts, agency. Lawful object, must not be illegal, immoral, fraudulent. If you want, I can prepare short notes, case law-based explanation, MCQs for Contract Act, unit on consideration and privity, one-page exam-ready chart. Is a concise exam-ready explanation of capacity to contract, legal disabilities, minors, unsound mind, restitution, and liability for necessaries, with references to ICA 1872, Sects 10, 11, 12, 64, 65, 68, Specific Relief Act 1963, Sec 33, and Indian Majority Act 1875. Capacity to contract, Sections 10, 11 Image, Section 10. For a valid contract, parties must be competent to contract. Section 11. Who is competent? A person is competent if 1. He is of the age of majority, 18 years, 21 in guardianship cases, Indian Majority Act 1875. 2. He is of sound mind, Sec 12. 3. He is not disqualified by any law. Thus, those lacking capacity include minors, persons of unsound mind, lunatics, idiots, intoxicated persons at the time of contract, persons disqualified by law, foreign sovereigns, alien enemies, insolvents, convicts. Minors and contracts. Who is a minor? Under Indian Majority Act 1875, a person below 18 years, general rule, 21 years if a guardian is appointed or property is under court of wards. A nature of minors' agreements. 1. Minors' agreement is void ab initio. Mahort Darmodas Ghose, 1903. Minor's agreement is absolutely void from the beginning. No estoppel against minor. He can plead minority even if he lied about his age. 2. No ratification on attaining majority. A void contract cannot be ratified after majority. 3. Minor can be a beneficiary. He may receive gifts, enforce contracts beneficial to him, be a promisee but not a promiser. 4. Minor's guardian can enter contracts. Guardian may enter beneficial contracts for minor, e.g., education, medical expenses. Persons of unsound mind, Section 12. A person is of sound mind if he is capable of 1. Understanding the contract, and 2. Forming a rational judgment as to its effects. Categories: 1. Lunatics, intervals of soundness and unsoundness. 2. Idiots, permanently unsound mind. 3. Intoxicated persons, temporary incapacity. A contract made during unsoundness is void. A contract made during lucid intervals, valid. During periods of unsoundness, void. Persons under legal disqualification. Examples: alien enemies, foreign sovereigns and ambassadors, insolvents, convicts. Such persons may have restricted capacity due to statutory prohibitions. Restitution in minors' agreements, general rule. Since a minor's agreement is void, no restitution of money is enforced against a minor ordinarily. Exception: preventing unjust enrichment. The law protects minors, but not fraud. A. Specific Relief Act, 1963, Section 33. Court may restore benefits received by minor to the extent they can be traced, but cannot enforce repayment of money or compel performance. Prevents unjust gain. Does not validate the contract. Sections 64 and 65 in minors. Section 64, rescission of voidable contracts. Not applicable to minors because their contracts are void, not voidable. Section 65, restitution on void or voidable agreements. Does not apply to minors' agreements because it presumes a contract existed. Minor's contract is void ab initio. However, courts may order restoration under equitable principles or Specific Relief Act, Section 33. Liability for necessaries, Section 68. What are necessaries? Goods, services suitable to the minor's condition in life, actual requirements at the time. Examples: food, clothing, shelter, medical expenses, education, legal services for defending minors' rights. Nature of liability. Minor is not personally liable. Liability is on the minor's property estate. Supplier can recover reasonable price of necessaries. Important case law summary. Topic: leading case. Minor's agreement void. Mohori Bibi v. Darmodas Ghose. Misrepresentation of age, no estoppel. Leslie v. Scheel. Necessaries, Nash v. Inman. Lucid intervals. Imperial Loan Co. v. Stone. Hare quick revision table. Area. Rule. Competency, Seclin. Majority plus sound mind plus not disqualified. Minor's contracts void ab initio. Ratification not allowed. Beneficial contracts enforceable for minor. Restitution limited. SRA Sec 3. Necessaries. 68. Minor's estate liable. Unsound mind. Sec 12. Valid only during lucid intervals. Sec 65. Not applicable to minors. If you want, I can prepare one-page chart, case law only notes, MCQs on capacity to contract, short 5-marker and 10-marker answers. Complete, crisp, exam-oriented explanation of quasi-contracts under the Indian Contract Act, 1872, sections 68 to 72, including concept, nature, and classification. To have a concept of quasi-contracts image. Meaning. A quasi-contract is not a true contract because there is no offer or acceptance, no agreement, no intention to create legal relations. Yet law imposes an obligation as if a contract exists to prevent unjust enrichment. Principle. No one should unjustly enrich himself at the cost of another. Nature. Obligation imposed by law based on equity, justice, and good conscience, duties similar to contractual duties, enforceable like a contract. Classification of quasi-contracts, section 6872. The Indian Contract Act provides 5 types of quasi-contractual obligations. Section 68. Claim for necessaries supplied. Rule. If a person supplies necessaries, goods, services essential for life, to a person incapable of contracting, minor lunatic, or someone whom such incapable person is legally bound to support, the supplier can claim reimbursement from the property of such incapable person. Key points. Minor is not personally liable. Only reasonable price recoverable. Necessaries depend on the person's status and actual need. Tabor, section 69. Reimbursement of person paying money due by another. Rule. A person who is interested in payment of money which another is bound by law to pay and who pays it is entitled to reimbursement. Examples. Tenant pays lawful act, no intention to act gratuitously, beneficial acceptance. Section 71. Responsibility of finder of goods. Finder of goods has same responsibility as a bailee. Rights of finder. Right to possession against all except true owner. Right to lien for expenses. Right to reward if announced. Right to sell goods if owner cannot be found, or goods are perishable, or cost of keeping value. Duties. Take reasonable care not to convert goods to his own use. Make reasonable efforts to find owner. Section 72. Liability for money paid or goods delivered by mistake or under coercion. Rule. A person who receives money by mistake, of fact or law, or anything delivered under coercion must refund or return it. Examples. Bank wrongly credits $10,000 to A. A must repay. Excess payment due to clerical error must be returned. Money paid under protest to release goods from illegal detention, refundable. Important. Unlike English law, mistake of law is also covered in India. Summary table. Section 68 to 72. Section. Quasi-contract. Type. Principle. 68. Necessaries to incapable persons, property liable, not person. 69. Payment by interested person, reimbursement. 70. Non-gratuitous act, compensation for benefit received. 71. Finder of goods, bailee obligations. Money paid, goods delivered by mistake or coercion. Refund, prevent unjust enrichment. Nature of remedy. Remedy is similar to contractual damages, but based on equitable obligation, not agreement. Courts enforce quasi-contracts to restore parties to fairness. Key exam points. Quasi-contracts equals rights imposed by law. No prior consent or promise. Aim, prevent unjust enrichment. Sections 68 to 72 exhaustively list situations. Remedy is restitution, not compensation for breach. If you want, I can also provide one-page revision chart, case laws for each section, 10 markers and 5 markers answer format, MCQs on quasi-contracts. Exam-oriented explanation of e-contracts, including their nature, formation, legislative framework, and judicial approach, with reference to Information Technology Act 2000, Sects 3 to 5, 1017. Nature and scope of e-contracts. What is an e-contract? An electronic contract, e-contract, is a contract formed through electronic communication such as emails, websites, mobile apps, click wrap, browse wrap, shrink wrap agreements, EDI, electronic data interchange. Nature. Like traditional contracts, e-contracts must satisfy Sec 10 of the Indian Contract Act 1872, lawful object, consideration, competent parties, free consent. Formed digitally, without physical signatures. Scope. Widely used in e-commerce, Amazon, Flipkart. Online banking and insurance, software licensing, social media platform agreements, government e-procurement and e-governance. Recognized and enforceable under Information Technology Act 2000 IT Act. Formation of e-contracts. A. Offer. Offer may be made via email, posting goods services on a website, invitation to treat unless terms say otherwise, digital advertisements, automated systems, e.g. booking websites. B. Acceptance. Acceptance may be clicking I agree, click wrap, proceeding without click, browse wrap, reply email, online acknowledgement, automated acceptance, Sec 11 IT Act. Acceptance must be communicated, unconditional, intentional, except browse wrap cases where continued use equals acceptance. C. Consideration. Digital consideration includes online payment, subscription fees, data provided by user, recognized as value. D. Intention and competency. Courts presume intention to create legal relations in e-commerce transactions. E. Modes of e-contracts. 1. Click wrap agreements. User clicks I accept. 2. Browse wrap agreements. Use of site equals acceptance. 3. Shrink wrap licenses. Terms inside software packaging. 4. Email contracts. Negotiation and acceptance via email. 5. E-data interchange contracts. Automated trade contracts. Legislative Framework, IT Act 2000, Secs 3 to 5, 1017. Section 3, Digital Signatures, recognizes digital signatures using asymmetric crypto system plus hash functions, ensures authenticity and integrity of e-documents. Section 4, Legal Recognition of Electronic Records. If law requires information to be in writing, electronic records are valid, gives legal equivalence to electronic documents. Section 5, Legal recognition of electronic signatures. Electronic signatures, including digital signatures, are valid for authentication. Section 10, Electronic contracts, provides legal validity to contracts formed electronically. Sections 10A, inserted 2008, Validity of e-contracts. Though not mentioned, important, declares contracts formed through electronic means as valid. Sections 11-17, Attribution, acknowledgement and dispatch of electronic records. Section 11, Attribution of e-records. An electronic record is attributed to a person if it was sent by him, by a person authorized by him, by an information system programmed by or on behalf of him, automated systems. Section 12, Acknowledgement of receipt. If sender requires acknowledgement, contract formation may depend on when acknowledgement is received. Section 13, Time and place of dispatch and receipt, critical for determining jurisdiction, when contract is formed. Rules. Dispatch, when record enters a system not under sender's control. Receipt, when it enters the receiver's system. Place, deemed to be place of business of sender-receiver. Sections 14-17, Secure electronic records and signatures. Secure electronic records equals records authenticated using secure methods. Secure electronic signature, signature using approved technologies, ensuring integrity. Judicial approach to e-contracts in India. Courts generally uphold e-contracts, provided consent is express, terms are accessible, user had chance to read terms, there is no coercion or unfair terms. Key cases. 1. Trimex International FZEV, Vedanta Aluminium Ltd., 2010. Email exchanges constituted a valid contract. No formal signature required. Harsha 2. Tamil Nadu Organic PV Ltd. State Bank of India 2014. Click wrap agreements valid and enforceable. 3. LICV Consumer Education and Research Center. Standard form contracts acceptable unless unconscionable. 4. Specht v. Netscape Communications, U.S. Persuasive. Browse wrap invalid if terms not reasonably brought to user's notice. Key issues in e-contracts. A. Consent. Users must be able to review terms. Failure may invalidate consent. B. Authentication. Electronic and digital signatures validate identity and intention. C. Jurisdiction. Sec 13 IT Act helps determine place of contract. D. Data privacy. Terms must comply with privacy and security standards. E. Evidence. Electronic records admissible under Indian Evidence Act, Sec 65B, 4 and 5. Quick revision table, topic, key points. Nature. Digital form of traditional contracts. Formation. Offer plus acceptance through electronic mode. Types. Click wrap, browse wrap, shrink wrap, email contracts. IT Act, Secs 3 to 5, electronic signatures and legal recognition. Secs 1017, formation, attribution, acknowledgement, place time. Judicial approach. Courts enforce e-contracts if free consent clarity. Issues. Authentication, jurisdiction, privacy, evidence. if you want. I can also prepare one-page summary chart, MCQs for e-contracts, short 5-marker and 10-marker answers. Exam-ready explanation of remedies for breach of contract, including damages, types, assessment, remoteness, mitigation, penalty, and liquidated damages, with references to Indian Contract Act 1872, sections 73 to 74. Remedies for breach of contract, overview. When a contract is breached, the aggrieved party is entitled to be compensated for the loss caused. Sections 73 and 74 of the Indian Contract Act deal with damages, remoteness, mitigation, penalty, and liquidated damages. Damages, Sec. 73. Image, meaning. Damages equals monetary compensation for loss caused by breach. Purpose, to put the injured party in the position he would have been in had the contract been performed, not to punish. Types of damages. 1. Ordinary general damages. Naturally arise in the usual course of things. Direct consequence of breach. Awarded as a matter of right. Case, Hadley v. Baxendale. 2. Special damages. Not naturally occurring, arise due to special circumstances. Recoverable only if these circumstances were communicated to the other party. 3. Exemplary punitive damages. Awarded not to compensate but to punish in rare cases. Examples: breach of promise to marry, wrongful dishonor of check by bank. 4. Nominal damages. Symbolic damages when legal right is violated but no actual loss suffered. 5. Liquidated damages and penalties, Sec. 74, some mentioned in contract for breach. Indian law, court awards reasonable compensation, whether the sum stated is penalty or liquidated damages. 6. Vindictive damages, for mental suffering or reputation loss, rare in contract. Basis of assessment of damages. A. Causation loss must be caused by the breach, not by external factors. B. Certainty damages cannot be awarded for speculative or remote losses. C. Remoteness of damages based on Hadley v. Baxendale rule, incorporated into Sec. 73, damages recoverable only for 1. Losses naturally arising, or 2. Losses within reasonable contemplation of both parties at the time of contract. Hack remoteness of damages, Sec. 73, recoverable, direct loss, foreseeable losses, losses communicated as special circumstances. Not recoverable losses, indirect losses, losses due to unforeseeable events. Example: if delay in delivering a machine causes stoppage of production, recoverable only if seller knew production depended on timely delivery. Measure of damages. A. Damages for non-delivery equals difference between contract price and market price on the date of breach. B. Damages for delay equals loss caused due to delay, if foreseeable. C. Damages for defective performance, cost of repair, replacement, or reduction in value. D. Damages for mental agony, generally not recoverable, except in breach of promise to marry, holiday travel contracts. Mitigation of damages. The injured party must take reasonable steps to reduce loss. Principles: cannot claim losses that could have been avoided. Must act like a reasonable person in similar circumstances. Example: if seller refuses delivery, buyer must try to buy same goods elsewhere at reasonable price. Penalty and liquidated damages. Sec. 74. Liquidated damages. Pre-estimated reasonable amount of damages agreed by parties. Penalty. Excessive, disproportionate sum intended to secure performance. Indian position. Sec. 74. India does not strictly distinguish between penalty and liquidated damages. Court will award reasonable compensation, not exceeding the amount stated in the contract, even if no actual loss is proved. ONGC v. Sawpipes Ltd. 2003. Key features: party claiming must show breach, but not necessarily actual loss. Court examines if amount is a genuine pre-estimate or penal. Important case law topic: leading case, remoteness. Hadley v. Baxendale. Liquidated damages, ONGC v. Sawpipes, SC. Reasonable compensation, Faith Chan v. Balkishan Das. Exemplary damages, Gibbons v. Mitchell. Promise to marry. Concept: section rule, key point. General damages, Sec. 73, natural and direct losses. Special damage must be communicated. Nominal damages, common law, no actual loss. Exemplary damages, rare, punitive. Remoteness, Hadley v. Baxendale, foreseeability test. Mitigation, judicial principle, minimize loss. Penalty versus liquidated. Sec. 74, court awards reasonable compensation, exam tip. For all questions on damages, always refer to Hadley v. Baxendale, remoteness. Fairchand, reasonable compensation. ONGC v. Saw pipes, proof of actual loss, not necessary if LD is reasonable. If you want, I can prepare one-page revision chart. Case law only notes MCQs on damages, Sec 7374. Ready-made 5-marker, 10-marker answers. A complete, structured, exam-oriented explanation of discharge of contract under the Indian Contract Act, 1872, sections 37 to 67, covering modes of discharge, performance, frustration, supervening impossibility, effects, and discharge by agreement and novation. Discharge of contract, meaning. Image. A contract is discharged when the obligations created by it come to an end. Modes of discharge of contract. 1. By performance, actual or attempted. 2. By mutual agreement, novation, alteration, rescission. 3. By impossibility, frustration. 4. By operation of law. 5. By breach, actual or anticipatory. 6. By lapse of time. ICA sections 37 to 67 primarily cover performance, supervening impossibility, and mutual agreement. Discharge by performance, sections 37-39. Section 37. Obligation to perform. Parties must perform or offer to perform their respective promises unless performance is dispensed with or excused under the law. 1. Actual performance. When both parties completely perform, contract ends. 2. Attempted performance, tender. Valid tender equals offer to perform. Unconditional, proper time and place, full performance offered. If refused, promiser is discharged. Section 38. Effect of refusal of performance of tender. Valid tender equals equivalent to performance, no liability if promisee refuses. Section 39. Refusal to perform, anticipatory breach. If a party refuses to perform the contract in future, the aggrieved party may treat the contract as terminated immediately, or wait till the time of performance. Discharge by agreement, sections 62 to 63. Section 62. Novation, rescission, alteration. A contract is discharged when parties agree to 1. Novation, substitution of a new contract in place of old one. Parties may change, terms may change. Old contract ends. 2. Rescission, mutual cancellation of contract. 3. Alteration, change in terms of contract by mutual consent. Effect, old contract is discharged, new contract, if any, becomes enforceable. Section 63. Remission, waiver, extension. Promisee may remit whole or part of performance, extend time, or accept any satisfaction instead of performance. No consideration is needed for remission. Discharge by impossibility, frustration. A. Initial impossibility, Sec 56 para 1. Contract void if impossible at the time of making. B. Supervening impossibility, Sec 56 para 2. Contract becomes void when performance becomes impossible or unlawful after formation. This is the doctrine of frustration. Doctrine of frustration, meaning. Contract is frustrated when an unexpected event destroys the basis of the contract or makes performance impossible or radically different. Indian courts treat Sec 56 as statutory frustration. Leading case India, Satyabrata Ghose v. Mugnaram Co., SC. Grounds of frustration, supervening impossibility. 1. Destruction of subject matter, e.g. music hall burns down, Taylor v. Caldwell. 2. Change of law or government intervention, contract becomes illegal. 3. Non-occurrence of essential event, e.g. cancellation of event for which contract was based. 4. Death or incapacity in personal service contracts. 5. Outbreak of war renders performance illegal or impossible. 6. Excessive delay due to uncontrollable events makes purpose meaningless. What does not amount to frustration, difficulty or inconvenience in performance, commercial impossibility, e.g. price rise, self-induced frustration, party's own fault, failure of third party, strikes or lockouts unless contract's foundation is destroyed. Case Durga Prasad v. Excise Commissioner. Effects of frustration, Section 56 para 3 and Section 65 under Sec. 56 contract becomes void automatically when performance becomes impossible. Under Sec. 65, when a contract becomes void, any benefit received under the contract must be restored or refunded. Practical effects. Parties discharged from future obligations, money paid, refunded, compensation possible for partial performance in some situations. Discharge by breach, Sec. 39. Actual breach occurs at time of performance. Anticipatory breach occurs before performance is due. Aggrieved party may treat contract as discharged or wait for actual breach. Discharge by operation of law. Examples: insolvency, merger of rights, death for personal contracts, unauthorized alteration by one party. Discharge by lapse of time. When limitation period expires, contract becomes unenforceable. Quick revision table, mode, section, key points. Performance, 37 to 39. Actual tender, anticipatory breach, agreement. 62-63. Novation, alteration, rescission, remission, 56. Initial plus supervening impossibility, frustration, event makes performance impossible, effects, 56 and 65. Contract void, restitution, breach, 39. Actual and anticipatory key cases to remember. Topic: frustration, Satyabrata Ghose v. Mugniram Bangur. Destruction, Taylor v. Caldwell, non-occurrence, Krell v. Henry. Commercial impossibility, Alopi Parshad v. Union of India. Self-induced frustration, Maritime National Fish Limited v. Ocean Trawlers. If you want, I can also provide one-page chart, case law only notes, MCQs on sections 37-67, ready 5-marker and 10-marker answers. Structured, exam-ready explanation of limitations on freedom of contract under the Indian Contract Act 1872, sections 23 to 30, covering void and voidable agreements, unlawful agreements, public policy, restraints, uncertain agreements, wagering agreements, etc. Freedom of contract and its limitations. Image. While parties are free to contract, this freedom is not absolute. The Indian Contract Act imposes restrictions to protect public interest, morality, legality, fairness. Sections 23-30 specify the circumstances where agreements become void, voidable, or illegal. Void versus voidable agreements. Basis: void agreement, voidable agreement, fairment. Definition: not enforceable by law from the beginning, enforceable at option of one party only. Nature: no rights and obligations, binding until rescinded. Cause: illegality, impossibility, uncertainty, restraint of trade, etc., coercion, undue influence, fraud, misrepresentation. Example: agreement in restraint of marriage, contract formed under coercion. Section 23, unlawful consideration and object. An agreement is void when the consideration or object is a. forbidden by law. Example: sale of smuggled goods. b. defeats the provisions of any law. Example: agreement to evade tax. c. fraudulent. Example: agreement to defraud a bank. d. involving or implying injury. Example: agreement to harm reputation, property. E. immoral. Examples: agreements for prostitution, living in adultery. F. opposed to public policy. Examples: trading with enemy, marriage brokerage contracts. If consideration object is partly unlawful, Sec. 24, agreement is void if unlawful part cannot be separated. Public policy. When agreements are void, public policy refers to principles safeguarding public welfare. Agreements opposed to public policy include 1. trading with enemy, 2. marriage brokerage contracts, 3. interference with course of justice, 4. sale of public offices, agreements restricting parental rights, 6. agreements promoting litigation, maintenance and champerty, 7. agreements to commit crime or fraud, 8. agreements in restraint of personal liberty, courts apply public policy cautiously, unruly horse. Agreements without consideration, Sec. 25, general rule, no consideration, no contract, void. Exceptions, valid without consideration. 1. Natural love and affection, written and registered, Sec. 21. 2. Past voluntary services, Sec. 25-2. 3. Promise to pay time-barred debt, written and signed, Sec. 25-3. 4. Completed gifts. 5. Contract of agency, Sec. Agreement in restraint of marriage, Sec. 26. Every agreement restraining the marriage of any person other than a minor is void. Examples: contract preventing someone from marrying a particular person, void. Agreement in restraint of trade, Sec. 27. General rule: all agreements restraining lawful trade or profession are void. Examples: a promises not to start business for life, void. Employment contracts restricting future employment, void unless reasonable. Exceptions: 1. Sale of goodwill, seller may agree to reasonable restraint. 2. Partnership Act exceptions, Secs. 11, 36, 54, 55. restraint during partnership or after dissolution. 3. Trade combinations, valid if promoting trade, not creating monopoly. Agreements in restraint of legal proceedings, Sec. 28. Agreements removing the right to approach courts or limiting time to sue are void. Examples: agreement stating no party shall sue in court, void. Reducing limitation period by contract, void. Arbitration agreements, valid exception. Hack agreements void for uncertainty, Sec. 29. If terms are vague or uncertain, the agreement is void. Examples: A agrees to sell nice goods, vague. A agrees to pay reasonable sum, uncertain unless determinable. Agreements by way of wager. 30. Meaning, a wagering agreement is one where parties bet on a future uncertain event, and each stands to win or lose depending on event outcome. Characteristics: mutual chances of gain-loss, no interest in event except winning or losing, dependent on uncertain event, no control of parties over event. Legal status in India. Wagering agreements are void. Sec. 30. Not illegal except in Gujarat, Maharashtra, under Bombay Prevention of Gambling Act. Exceptions: horse race contribution above 500 is valid. Share market transactions, delivery intended, are not wagers. Contracts of insurance, not wagers, they involve insurable interest. Agreements void due to partial unlawful consideration, Sec. 24. If lawful and unlawful parts are separable, lawful part enforceable. If inseparable, whole agreement void. Example: A lends money to B for running a shop, lawful, and smuggling, unlawful. If inseparable, void. Other void agreements, under sections 23 to 30. Agreements contingent on an impossible event, Sec. 36-37. Agreements to commit crime, marriage brokerage contracts. Agreements to deceive creditors. Quick revision table. Type of agreement, section, legal effect. Unlawful consideration object, 23, void. Agreement without consideration, 25, void, except 3 cases. Restraint of marriage, 26, void. Restraint of trade, void, except goodwill and partnership. Restraint of legal proceedings, void. Uncertain agreements, 29, void. Wagering agreements, 30, void. Partial illegality, 24. Whole agreement void if inseparable. Next, important cases. Topic: Case, public policy. Garulal Parak v. Mahadiodas. Restraint of trade, Niranjan Shankar Golakari v. Century Spinning. Service restraint, Superintendents Co. v. Krishan Murgai. Wagering agreements. Carlo v. Carbolic Smoke Ball Co. Not a wager. Uncertain agreements. Scammell v. Austin. If you want, I can also prepare 1-page revision chart, case law only notes, 5-marker, 10-marker model answers, MCQs on sections 23 to 30. Complete, clear, exam-ready explanation of free consent under the Indian Contract Act 1872, sections 13 to 22, covering definitions, types, coercion, undue influence, fraud, misrepresentation, mistake, and effects on contracts. Free consent, section 13 and 14 image. Section 13, consent. Consent is 2 or more persons are said to consent when they agree upon the same thing in the same sense. Consensus ad item. Section 14, free consent. Consent is free when it is not caused by 1. Coercion, Sec. 15, 2. Undue influence, 6.3. Fraud, Sec. 17, 4. Misrepresentation, Sec. 8.5. Mistake, Sec. 20 to 22. If any of these vitiate consent, contract becomes voidable, Sec. 19 to 19a, except for bilateral mistake, which makes it void. Section 15, definition. Coercion equals committing or threatening to commit any act forbidden by the IPC, or unlawful detaining or threatening to detain property with intention to obtain consent. Key features. Act must be forbidden by IPC, even if done outside India. Includes threats to person or property. Includes psychological pressure through illegal threats. Effect, Sec. 19. Contract is voidable at the option of the party whose consent was obtained by coercion. Undue influence, Section 16. When does it arise? One party dominates the will of the other to obtain an unfair advantage. Conditions for undue influence. 1. Relationship of dominance. 2. Use of position. 3. Unfair advantage gained. Examples of presumed dominance: parent-child, guardian-ward, doctor-patient, lawyer-client, spiritual leader-disciple, a person in mental or financial distress. Effect, Section 19A. Contract is voidable. Court may also set aside contract on fair terms. Partial enforcement possible. Fraud, Section 17. Definition. Fraud includes 1. Suggestion of false fact knowingly. 2. Active concealment. 3. Promise without intention to perform. 4. Any act fitted to deceive. 5. Fraud declared by law. Essentials. Intention to deceive is necessary. Silence is not fraud unless there is a duty to speak, e.g. insurance contracts. Effect, Section 19. Contract is voidable. Aggrieved party may rescind contract, claim damages, unlike in misrepresentation. Misrepresentation, Section 18. Definition. Misrepresentation includes 1. Positive assertion made without knowledge of falsity. 2. Breach of duty causing misleading but without intent to deceive. 3. Innocent act leading to mistake. Difference from fraud. No intention to deceive. Party believes statement to be true. Effect, Sec. 19. Contract is voidable, except where the aggrieved party had the means of discovering truth with ordinary diligence. Contract not voidable. Mistake. Sections 20 to 22. Mistake equals misunderstanding or erroneous belief about essential facts or law. A. Mistake of fact. 1. Bilateral mistake, Section 20. Void. Both parties mistake an essential fact. Examples. Subject matter does not exist. Identity of subject matter. Quantity or quality fundamentally misunderstood. The contract is void. 2. Unilateral mistake. Sec. 22. Valid. One party mistaken. Contract generally valid unless mistake is about the identity of person contracted with or mistake is about the nature of the contract. B. Mistake of law. I. Indian law. Mistake of Indian law is no excuse. Contract valid. T. Foreign law, Sec. 21. Treated as mistake of fact, contract may be void. Effective factors vitiating free consent, Section 19 and 19A. Factor, section, legal effect. Coercion, 15, voidable. Undue influence. 16, voidable. Court may modify terms. Fraud, voidables damages, misrepresentation. 18, voidable, no damages unless duty breached. Bilateral mistake, 20 void. Unilateral mistake, 22 valid. Exceptions exist. Remedies available. Rescission, restitution, damages in cases of fraud. Insist on performance if party chooses not to rescind. Important case law topic. Case coercion, Chikam Amaraju v. Chikam Sashama. Undue influence, Williams v. Bailey. Rani Annapurna v. Fraud, Derry v. Peak. Misrepresentation, Redgrave v. Heard. Mistake, bilateral. Bell v. Lever-Bras. Mistake, nature of document. Foster v. McKinnon. Now, quick revision table. Term, key points. Coercion, IPC-based threat, unlawful detention. Undue influence, dominance, unfair advantage. Fraud, intentional deception. Misrepresentation, innocent false statement. Bilateral mistake, void contract. Unilateral mistake, generally valid. If you want, I can also prepare one-page revision sheet, case law only notes, short 5-marker and 10-marker answers. MCQs for practice on sections 13 to 2.